All right, and of course, the one, the only, Jessica Anderson from Anderson Kucher. Good morning to you.
Good morning, guys.
I'll tell you, Jessica, let's get right into the love court this morning because we got a tricky one this morning. It involves terminating the parental rights.
Right. So, dear Jessica, to just jump right in, my son was born in June 2014, and we were not married, but both signed the birth certificate. And the last physical contact with his biological father was November 2014. The father's contacts have been holidays from 2015 to 2016, quote, Happy Thanksgiving, Merry Christmas, Happy Easter, and finally, Happy Birthday to the child in 2016. As I understand, I can't terminate his parental rights since I'm a single parent. Is this true? If something happens to me, is my son going to go to a total stranger simply because of a signature on a birth certificate? How do I protect my child and make sure he goes to the family he knows? And what can I do to make sure I have physical and legal custody? So I know we've talked about terminating parental rights in the past, and I know that I've said that it's really difficult unless you have a step parent there to, pick up the role. And that's still the case. That is true. It's very difficult. It's not impossible, though. If he has not been in contact and is not financially supporting this child, and it's been like 5 years, then she certainly has a basis to claim that he's abandoned the child, and she can seek to terminate his parental rights. Whether or not it gets granted depends on whether or not he contests it. It depends on, the judge and how the judge feels about the situation. I mean, these are very, very fact-specific inquiries. But just keep in mind that terminating parental rights also means terminating parental obligations. So if he's under a court order for child support, that'll go away, and as will her right to seek that from him in the future.
Now, if they don't rule in her favor or find she has a leg to stand on, isn't the only way to terminate parental rights to be if he actually relinquished them and he signed a document saying no?
They're both the same. I mean, if he relinquishes, that probably will not be taken by the court. You can't just say, I don't want to support this child anymore, so I'm going to give up my rights. Judges, again, that's the situation. Maybe they would agree to that if there was a stepdad coming in to adopt or, to be, become the parent, but they're not going to do that just because somebody wants to avoid their support obligations.
Do you think the judge, do you think the judge is going to want to talk to the child at all? Will they get the child's opinion on
probably
this?
Not.
Not at 7?
No,
child's too young. Yeah.
Right. But I do want to answer her question regarding, appointing a guardian. So in her situation, I would designate a third party as the guardian in her estate planning. And if something bad were to happen to her, the designated guardian would take custody. Assuming bio dad is still out of the picture and his rights are not terminated, he'd be notified through the guardianship court that mom had passed away. And in this circumstance, the child wouldn't automatically go to bio dad, so long as her estate planning designated someone else. But the guardian may be in a position to have a custody battle with dad. So if dad wants custody, he certainly would have, the right as the biological father with, still having parental rights to fight about that in court. But, on the other hand, if dad were in the picture exercising custody on a regular basis, something were to happen to mom, yes, the child would automatically go to dad, regardless of whoever mom puts in her estate planning. So does that make sense?
Go ahead.
Sorry, I was just going to say, is her fear valid that, say, she doesn't put this in her estate planning, she doesn't designate a guardian in place of herself, and dad doesn't want any responsibility? Is her fear valid that the child may go into the system?
Well, the child would go into the system.
Yikes.
I mean,
the dad could still refuse at that point?
If there were no one, and if there were no one there to take the child, of course the child will go into the system. But probably there's someone there, right? So grandma has the child and mom's gone, and so grandma needs legal rights to be the guardian. So grandma would petition the court to say, my daughter's gone, bio dad's out of the picture, I need to have custody of this child. And that's how that would happen.
That
and then
sounds
dad
like a
would get
nightmare.
Dad would get notified, and then dad would have the option of either just agreeing that grandma or whoever it is could be the custodian or fighting for the kid.
So she's right to be asking these questions now. She should probably get it taken care of sooner rather than later.
Right. If you're a single parent, these are things you have to think about.
Huh, crazy. Okay, if you ever have questions for Jessica inside the Love Court, we do it every single Friday at 8:10. Head to our website at alice965.com. Click on the Jessica Anderson portal. Jessica, you answer every single stinking question you receive.
Yep. And we go back and forth, and then sometimes, they need more information, so they come in for consultation.